Thanks so much, Kelly, and good afternoon, everybody. My name is Jillian Thomas. I'm a senior staff attorney with the ACLU Women's Rights Project, and I'm joined today by Cynthia Thomas Calvert, who's a senior advisor with the Center for Work-Life Law, and Liz Morris, the deputy director of the Center for Work-Life Law. And we're so grateful to the Pennsylvania Legal Aid Network for this invitation to talk about the newly enacted Pregnant Workers Fairness Act. We're thrilled to have the opportunity also to speak to so many advocates working with the workers who are going to be most in need of workplace accommodations. Low-wage workers in physically strenuous jobs, ranging from retail to nursing to custodial, and food service. A wide range of jobs are implicated by this statute. Those workers obviously are also the ones for whom the consequences of being denied necessary accommodations are so grave, and can include job loss. So having to choose between a healthy pregnancy and a paycheck is a Hobson's choice no worker should ever face, and this law will go a long way toward assuring that those kinds of decisions don't have to be made. Just a quick note about our organizations and who we are and how we come to this work. The ACLU Women's Rights Project and the Center for Work-Life Law have been at the forefront of, first of all, attempting to get the PWFA enacted. It's over a decade in the making, but also in advocating on behalf of pregnant, lactating, and pregnant lactating and parenting workers. We've used litigation, policy advocacy, and technical assistance, working with not just workers and attorneys, but also with employers to educate them about the physical realities of pregnancy and lactation, as well as assisting with strategies for remedying discrimination against those vulnerable groups. Our bios are in the handouts, as well as our contact information, and we urge you to be in touch with us. As you heard, there are going to be some handouts provided to you after the session. They're really extremely substantive, and we urge you to keep them by your side as you counsel your clients. If you have questions during the presentation, please drop them in the chat. We're going to save questions for the end, the last 15 minutes. We're hoping that'll be a good, robust time to answer your questions. If you're watching the recorded version of this session, the Q&A portion will not be included in the recording, and so you should feel free to reach out to any of us with your questions after today. This is one in a series of webinars that the Center for Work-Life Law and ACLU are partnering to present. We have in the works a session on the PUMP statute that recently was enacted as well. You'll hear a little bit about that today, but it's the first sweeping federal protections for workers needing to pump breast milk at work. So we're going to be having a session in the next couple of months about that, as well as a session that is about the early stages of a PWFA case, sort of getting your claims and anticipated defenses in order, and then how to select clients and start planning for discovery. So keep an eye out for those forthcoming seminars. And we also are very eager, by the way, to know what would be of most use to you and your clients. So we'll be sending out a brief survey in the next day or two, also to get your input. Obviously, also please feel free to contact us directly or put them in the chat. Last couple of preliminary notes before we begin with substance. If you decide to represent a worker utilizing the PWFA, we urge you to contact us. We are here and ready and willing to provide technical assistance as you start using this exciting new statute. We're happy to talk through potential claims, fact issues, and you'll be helping us as well by keeping us apprised of the kind of pushback that employers might be raising, or the other kinds of resistance that you might be encountering or your clients might be encountering. Also, if you're contacted by a potential plaintiff who you're not able to help for whatever reason, the Center for Work-Life Law has a legal network of attorneys that routinely take pregnancy accommodation cases. And so you should definitely reach out to the network, and the contact information for the network is in these material, in the PowerPoint and also in the handouts. Services are available in English and Spanish and additional languages on request. Additionally, the ACLU is extremely interested in hearing about potential litigation, especially with respect to accessing abortion care using the PWFA, and issues relating to the religious exemption that's in the bill. So please also reach out to ACLU with potential clients, although we're in touch with the Center for Work-Life Law, so if you contact them, we'll undoubtedly hear from them too. And the last thing I'll say before we get going is the PWFA includes a provision for the Equal Employment Opportunity Commission, the EEOC, to issue implementing regulations. And some of you may know those don't have the force of law, but they are considered by courts to be persuasive authority in interpreting the PWFA. And the EEOC is going to be putting out a notice of proposed rulemaking. We're anticipating it sometime in the next month or 2 months. And we would urge you to, our group, as well as some other, advocates, are going to be providing template comments for people to use to provide their own feedback about what this law means to their clients. And those kinds of real life stories are essential for the EEOC to hear how these issues of pregnancy accommodation are playing out in the real world with workers who really need the law's protections. And so we urge you to submit comments when that time comes. So watch this space for that next phase of PWFA's implementation. So with that, I will turn the mic over to Liz Morris to talk about what the PWFA is. Liz.
Great, thank you. And thank you. I'm Liz Morris. I'm the Deputy Director at the Center for Work-Life Law. And before I jump into the PWFA, want to share that in addition to the attorney network that we operate at the Center for Work-Life Law, we have a free legal helpline for workers who are seeking assistance in all states. And so if there's anyone who you're unable to help for whatever reason, perhaps because they're in another state, please do take advantage of the services that we offer on our free legal helpline. We're able to give folks information about their legal rights and assist people with negotiating for what they need with their employers. With that, going to shift gears now, talking about the Pregnant Workers Fairness Act, which is a truly exciting win. Really can't overstate what a huge deal this law is. Pregnant workers have desperately needed these protections, and now they finally have them. There are going to be untold benefits for economic security, for maternal and child health, not to mention for gender and racial justice. The primary goal of the Pregnant Workers Fairness Act is to keep pregnant employees working and earning an income while remaining safe and healthy on the job. And accommodations are often needed to achieve that goal. If you've ever been pregnant or close to somebody who's pregnant, then you understand perhaps all too well the many physical and mental changes that come along with pregnancy. For example, pregnancy often causes nausea, headaches, fatigue, back pain, swelling in the legs and the hands, bladder control issues, and the list does go on. And then on top of those sort of normal side effects of pregnancy complications can arise. And accommodations may be needed for those, for example, to manage gestational diabetes, or if an employee has high blood pressure, which in pregnancy is called preeclampsia, prenatal postpartum depression, and unfortunately that list goes on as well. Accommodations may also be needed by pregnant workers so that they can prevent harm to their pregnancy that could be caused by hazardous workplace conditions. So for example, pregnant people need to avoid exposure to harmful toxic chemicals that may be present in their workplace, very physically demanding work, tasks that could cause falls or injuries, particularly to the abdomen. And so when employers fail to provide the workplace accommodations that their pregnant employees and their postpartum employees need to stay healthy and safe, it can lead to serious negative health consequences like preterm birth, miscarriage, and even stillbirth. The US has one of the highest maternal mortality rates amongst wealthy nations, and the risk of death is 3 times higher for Black women as compared to white women. Pregnant workers who don't receive the accommodations that they need may also be forced out of the workforce, which of course can have severe economic consequences for them and for their children for years to come. And so can't overstate what a huge deal this really is and how much good it is going to do for folks. With that background about why this matters, going to shift gears now and talk about the law. So here's an overview of the Pregnant Workers Fairness Act, which folks often refer to as the PWFA or as PWFA. So it goes into effect on June 27th, 2023. Not in effect yet, but we're getting really close. And it has a similar framework to the ADA. It adopts many of the definitions and the interpretations of the Americans with Disabilities Act. So attorneys who are familiar with the ADA are going to hear a lot of familiar terms today. And some of those terms have the same meaning as in the ADA context, but others are going to be understood, other terms are understood differently in this PWFA context. And that's one of the complexities that our webinar series that Jillian mentioned is really going to be diving into. The EEOC, by direction of the statute, is going to issue regulations by December 27, 2023. As Jillian mentioned, we'll get information out about how to comment on the proposed regulations. And also, once the final regulations are out, we will notify you of that as well. Covered entities, employers that are covered by the law. It's defined broadly to cover almost all employers who are subject to federal anti-discrimination laws like Title VII. So that includes private employers of 15 or more employees, federal, state, and local government employers, employment agencies, and labor organizations. Okay, so this text is sort of the main show of the Pregnant Workers Fairness Act, the language that gives a right to receive a reasonable accommodation. It's an unlawful employment practice to not make reasonable accommodations to the known limitations related to the pregnancy, childbirth, or related medical conditions of a qualified employee unless the employer can demonstrate that the accommodation would impose an undue hardship. So in the next few slides, we're going to unpack this and talk more about what each of these terms actually means. So first, employers have to make reasonable accommodations. And reasonable accommodations means the same thing here as it does under the Americans with Disabilities Act. So in the pregnancy context, here are some examples of pregnancy-related reasonable accommodations. Just fix this thing on my screen. Okay, here we go. So first example is a chair to sit on while checking out customers at the cash register. For example, that may be needed due to back pain. Permission to carry a water bottle on the factory floor. Pregnant people have both increased thirst as well as increased need for water intake. Additional breaks to check blood sugar and to eat, perhaps if someone has gestational diabetes. Moving the workstation closer to the bathroom. That accommodation may be needed for bladder control issues or for nausea. A temporary transfer to an alternate position to avoid exposure to toxins during pregnancy or while nursing. So agricultural workers who are working around pesticides, or workers who are working with dry cleaning chemicals may need to be temporarily placed in an alternate job position to protect their health or the health of their child. Permission to work from home to avoid COVID exposure risk. Pregnant people are at higher risk for serious outcomes from COVID than non-pregnant people. Also, COVID can lead to negative pregnancy outcomes like miscarriage or even stillbirth. And there's some data emerging that there are impacts on children when they're in utero that can be seen later in their lives if their birth parent is exposed to COVID during pregnancy. Excusal from night shifts or mandatory overtime, time off to attend prenatal appointments or to access an out-of-state abortion, and leave needed for prenatal hospitalization or postpartum depression or anxiety. So these are all just examples of accommodations that come up in the context of pregnancy. The key when you're working with a client or with their employer, negotiating with their employer or talking with their healthcare provider, is to really be creative in identifying accommodations that may be effective in meeting their health needs given their job duties. And so the Center for Work-Life Law has a resource, Pregnancy, Childbirth, and Related Medical Conditions, Common Workplace Limitations and Reasonable Accommodations Explained. It goes through, it's very comprehensive, goes through all sorts of reasons why somebody may need an accommodation during pregnancy. And then the document identifies various accommodations that may be responsive for those particular needs. And that resource is in your handout, so encourage you to check that out. Okay, so going back to this text, accommodations have to be made for the known limitations related to pregnancy. So a known limitation is a mental or physical condition that the employee has communicated to the employer. And it doesn't have to be a disability, for example, as that term is defined by the Americans with Disabilities Act or any other definition of disability. It only needs to be a limitation. I think somebody may not be on mute. If one of the presenters could try and mute them, that would be helpful. Thank you. Okay, so the accommodations have to be made for limitations related to pregnancy, childbirth, or related medical conditions. Now, this term isn't defined by the Pregnant Workers Fairness Act. However, the language is taken from the Pregnancy Discrimination Act, or the PDA. And so we have years of interpretation from courts and from the EEOC about what this term means. And the good news is that they have interpreted it broadly to include normal physical changes of pregnancy and childbirth. So that includes, again, things like back pain or morning sickness, swelling, bladder control issues. It also includes complications of pregnancy and childbirth. So things like gestational diabetes, prenatal, postpartum depression and anxiety. It also includes lactation, abortion, miscarriage and pregnancy loss, fertility treatment, and menstruation. So accommodations have to be made for qualified employees. So what does that mean to be a qualified employee? A qualified employee is an employee or an applicant who can perform the essential functions of the job, either with or without a reasonable, with or without an accommodation. And so many of you probably know this language if you're familiar with the ADA. If you are familiar with this language, you probably also know that oftentimes employers are successful at having cases thrown out of court by arguing that the employee who needs an accommodation isn't qualified because they're not able to perform certain essential functions of the job, even with an accommodation. However, under the Pregnant Workers Fairness Act, the definition of qualified employee is broader, more expansive than it is under the Americans with Disabilities Act. An employee who cannot perform the essential functions of the job is still qualified under the Pregnant Workers Fairness Act if these three qualifications are met. The inability to perform the essential functions is temporary. The essential functions can be performed in the near future, and also the inability can be reasonably accommodated. And because pregnancy is temporary, it's going to almost always be true that the inability to perform the essential function is going to be temporary. Okay, so accommodations have to be provided unless providing them would impose an undue hardship on the employer. Undue hardship means the same thing as under the ADA. The ADA defines it as an action requiring significant difficulty or expense when considered in light of factors such as the cost of providing the accommodation to the employer's overall resources, the nature of the employer's business operations, and so on. And as we're going to discuss a bit later in the presentation, it's going to be unlikely that pregnancy accommodations will impose an undue hardship due, again, to their temporary nature. All right, the interactive process, just like in the Americans with Disabilities Act, the employer and the employee are going to typically use the interactive process to identify an appropriate, reasonable accommodation, unless the accommodation is obvious and then no further discussion may be necessary. And so interactive process has the same meaning as under the Americans with Disabilities Act. So that means that this back and forth dialogue between employer and employee is going to include an analysis of what the employee's job duties are, what the essential functions of the job are, of course, keeping in mind that it's okay if they can't be performed temporarily, so long as they can be performed in the near future. It's also going to include a conversation with the employee about what they can do, what they can't do, and how a reasonable accommodation might assist them with doing the tasks of their job. Also, identification of what accommodations are possible and what accommodations would be effective in meeting the employee's needs, as well as at least a consideration of what the employee's preferences are. They're not entitled to their first choice accommodation necessarily, but that is something the employer is meant to consider. Okay, so that was sort of the main show of the Pregnant Workers Fairness Act, the right to receive a reasonable accommodation, but there are other unlawful employment practices under the PWFA to be aware of.
Liz, I'm so sorry. If now is a good time, I just need to launch the first CLE poll.
Sure.
Attorneys need to respond for CLE credit. This is the first of two, and I will leave it up for 2 minutes if you can respond. And Liz, please feel free to continue. Sorry to interrupt.
That's okay, thank you. So we were just saying that there are several other unlawful employment practices under the Pregnant Workers Fairness Act to be aware of. And the first is that it's unlawful to force an employee to accept an accommodation unless one has been requested by the employee and the employer has engaged in the interactive process. It's also an unlawful employment practice. With regard to that first one, employees are not entitled to their first choice accommodation. I mentioned that earlier. so long though as the employer has identified and provided another accommodation that is also effective in meeting the employee's needs. The second unlawful employment practice is forcing an employee out on leave, whether the leave is paid or unpaid, if the employee doesn't want to take leave and another responsive accommodation, exists. And then finally, it's unlawful to use retaliation or coercion against an employee or any other individual related to requesting or using an accommodation or opposing unlawful practices. Let's discuss remedies. The remedies mirror Title VII or other anti-discrimination laws that might apply to employees who aren't actually covered by Title VII. And so that means administrative exhaustion is required, such as filing a charge with the EEOC or the relevant government employee's EEO office. The remedies for employees covered by Title VII are available here. So that's compensatory and punitive damages, except of course, public employers aren't subject to punitive damages. The damages caps from Title VII apply. Also, attorney's fees and costs of suit are available. And in this context, there is a good faith defense to damages. So the employer can raise a defense to damages if it shows that it made good faith efforts in consultation with the employee to identify and make a reasonable accommodation that would provide the employee with an equally opportunity. All right, just a few more things to know about the Pregnant Workers Fairness Act. The Pregnant Workers Fairness Act doesn't limit state or local laws that provide greater rights. In Pennsylvania, you all have laws in Philly and in Pittsburgh that do provide greater rights. So important to know that those greater rights, greater protections still apply and are available. And Jillian is going to talk more with you about what those greater protections are shortly. The Pregnant Workers Fairness Act does not require employee-provided health plans to cover any particular treatment or procedure. And finally, the Pregnant Workers Fairness Act adopts Title VII's exception for religious employers, which shields them from religious discrimination claims for favoring co-religionists. And that a co-religionist meaning an employee or an applicant that shares the same religion as the employer. And that's referred to as Section 702 in Title VII. But it's important to be aware that federal appellate courts unanimously hold that religious employers cannot discriminate on the basis of sex, which of course does include pregnancy. So that's the Pregnant Workers Fairness Act, or the PWFA, in a nutshell. We're going to delve into all of these provisions that we've touched on lightly here. We're going to delve into them more deeply in future webinar sessions. We want to help you to represent your clients with respect to filing charges, negotiating with their employers, rebutting common arguments against accommodation. So please do keep your eye out for those future trainings, and always feel free to reach out to folks on this webinar. Cynthia, Jillian, both extremely brilliant, and we are happy to help in any way that we can. Before I turn it over to Cynthia, I want to just briefly touch on another law, as if the Pregnant Workers Fairness Act wasn't enough. There's another law that was also passed at the same time, actually as part of the same package, as the Pregnant Workers Fairness Act. And that is the 2022 PUMP Act. And the 2022 PUMP Act amends the 2010 Fair Labor Standards Act, or FLSA, break time for nursing mothers provision. And that 2010 law provided a right to reasonable break time and private non-bathroom space to express milk for the employee's nursing child for 1 year after birth. And the 2022 PUMP Act extends coverage of that right to 9 million previously uncovered women of childbearing age, including teachers, registered nurses, and farm workers. So all of these folks now, actually almost all workers in the United States are now covered. I should say all employees, because of course, gig workers and other unclassified or other independent contractors are not covered, but all employees in the United States are covered by these break time and space provisions. There's one exception to that, which is airline crew members. So that's essentially pilots and flight attendants were excluded from coverage under this law. And the other thing that the 2022 PUMP Act does, in addition to extending coverage, is it gives employees a private right of action to sue for violations with damages available that are similar to the damages available for under an FLSA retaliation claim. Prior to the 2022 PUMP Act, there was no private right of action, so this is also super important. So keep an eye out for future trainings that we're going to be putting on with Neela on the PUMP Act. And with that, oh, and I should say the PUMP Act is already in effect and the private right of action is already in effect as well. With that, I'm going to turn it over to my colleague, Cynthia.
Wonderful. Well, thank you so much, Liz. At Work Life Law, we spend a lot of effort trying to get pregnancy accommodations for people who call our hotline under the PDA and the ADA. So we are so thrilled that we now have the everything study. We've been planning for how we're going to implement it. And what I'd like to do now is share with you some of our experiences with getting people accommodations and also how we plan to use this law going forward. So the process for requesting an accommodation under the PWFA is now much clearer. It's much simpler. Could we have the next slide, please? The process starts with the employee communicating to the employer that they have a limitation. They have some difficulty accomplishing their work. And there's really no magic words that the employee has to use. It can be very simple. It can be very clear. All they're trying to do is make sure that the limitation is known and that the link between the limitation and pregnancy, childbirth, or related medical condition is also made known. We have the next slide, please. And no particular detail has to be given, just very simple, very straightforward. So examples like, I have swollen feet and that makes it hard to stand, that's enough. Or I need to come in late every Thursday because I have a medical appointment. So both of those are enough for making the limitation known. And next slide, please. For making the link to pregnancy known, also very simple words: due to my pregnancy, following my miscarriage, because I recently gave birth, related to my gestational diabetes. Next slide. It's not required that this be in writing, although we strongly suggest it. Whenever we're advising people who call our hotline, we're suggesting to them that they make their requests in an email or see if their employer has a request form that they have to use, or maybe they're providing a doctor's note and that will suffice as a writing. Also, you may be making the request on their behalf, and perhaps it's a letter from you, and that's what the writing is. And we suggest that it goes to HR as well as to the supervisor, because supervisors, although they're the ones that have the day-to-day contact with the employee, they often don't know the laws and what they're required to do as much as HR, hopefully, does. And so we say, make sure that HR is included on any request for accommodations. Next slide, please. When requesting accommodations, the employee doesn't have to say to the employer, this is the specific accommodation that I want. However, if they do provide a specific accommodation request, it's going to improve their chances of getting what they want. It's also going to make it harder for the employer to say, oh, well, you know, I didn't know what you needed. I didn't know what you wanted. I didn't know what we could provide. Next slide, please. As Liz mentioned, we've given you some sources for coming up with ideas for brainstorming accommodations with your client. We spend a lot of time on the hotline talking with employees about what their job duties are and what their needs are, and trying to be as creative as possible in coming up with ideas. So as Liz mentioned, we've got the pregnancy accommodation chart or handout, whatever you want to call it, that it has great information about not only what the person's condition is that might make it difficult for them to work, but it also explains some of the background, some of the more detailed information about what that means in terms of their abilities and inabilities. And then each one of those conditions has several different possible accommodations included. But if that's not enough, we would suggest going to Ask Jan, which is the Job Accommodation Network, and they have great suggestions for people who need various forms of accommodation. And you'll find the link for that on the resources page in your handout. Next, please. So when we're helping our callers to brainstorm accommodations, one approach that we take is we think about the goal as opposed to the job description. So they might have a job description that says, it's your job to carry boxes from point A to point B. What we do is, instead of focusing on that word carry, we focus on what the objective is, moving boxes. And then we try to think of different ways that boxes can be moved. So maybe it's using a dolly or a cart. Maybe there's other assistive equipment that can be used. Maybe coworkers can help them with lifting. Next, please. Another approach that we take is suggesting that the job be restructured. So this is, again, looking at a job description, looking at what the employee actually does, and then coming up with a checklist of what they're able to do, what they're not able to do. If there is something that they can't do that is non-essential, we suggest just removing it. That's not controversial, very easy to do. But if it's essential, we still say to them, let's talk about removing it. And this is something that the PWFA, makes possible that we didn't have before. So this is very, very exciting for me. As Liz said, even if a job duty is considered essential, a job function is considered essential, it can still be removed if it's going to be temporary. In other words, the employee is going to be able to do the essential function at some point in the near future, and their inability to do it can be accommodated. So there are many different ways to accommodate. Here, a couple, they can trade tasks with their co-workers. So perhaps the pregnant employee does all of the paperwork and a co-worker does all of the physical labor. There are other ways also. You can have an employer who's dividing up all of the seated tasks and giving those to the pregnant employee, and then all of the other tasks that require physical labor get split up among other employees who are on the team. Next slide, please. Another approach we take is suggesting light duty or transfer to another position. Light duty can have a lot of different meanings, so we probe this a lot with people who call our hotline. Sometimes employers have specific positions set aside that are called light duty positions, and that has very specific meaning. Other times it's not the case, and so light duty just means something where the heavy physical labor is taken out of the job description. And then transfer to another position is something that people often forget to think about. So it's something that we focus on with the employee. What are their qualifications? What are the openings? What would help them to be able to continue to work in a different department or in a different capacity? And of course, as Liz mentioned, leave is a last resort only if there's no other way to accommodate the employee so that they can continue to work. Next slide, please. So often we hear that the person who's calling us on the hotline has no ideas, and maybe we're stumped as well. And in a situation like that, the best thing to do is to inform the employer with as much specificity as possible about what the employee can and cannot do, and really just put the ball in the employer's court, because the employer knows what's available. They know what can be changed, what can't be changed, what work can be spread around. And so they really should take the bull by the horns at that point. Their duty to accommodate is triggered as soon as there's a known limitation that's related to pregnancy, childbirth, and a related medical condition. And so it really is incumbent upon them to come up with something if the employee hasn't suggested something. Next slide. One thing I'd recommend is making sure that whatever the accommodation is that the employee is requesting, make sure that it is possible. We've seen situations under the ADA where the employer successfully defended against a failure to accommodate claim because they said that's just not possible. Either a position wasn't open, or they said that the employee didn't have the qualifications, or if the employee was asking to move to another office, they said, oh, there's no other office available, et cetera, just goes on and on. So we suggest making sure that it's possible. And then it's good to document the fact that it is available. So that might just be as simple as screenshotting a list of vacancies. Employers are always hiring. So just go to their that section of their website listing all of the vacancies and just take a screenshot. Next slide, please. So the interactive process is huge in this situation, and we suggest making sure that your client is prepared to deal with it. I had a caller to our hotline a few years ago who called me to complain. She was just all upset because her supervisor was trying to talk to her about a transfer. She had talked about how she needed accommodations, and the supervisor was trying to do what he was supposed to be doing under the interactive process, and she didn't like him and she didn't want to talk with him. So it's important to make sure that your client knows what to expect. And the interactive process doesn't have to be anything formal. It can be very informal, and it can vary with the circumstances. It might be one conversation. It might be a series of conversations that happens over days or weeks, but make sure your client can recognize it when it's happening. And when the need for the accommodation is obvious, or the way to accommodate is obvious, there really shouldn't be much of a need for discussion. And we are hoping that the EEOC will put that into their regulations. That's the way the ADA has been interpreted. Next, please. Now, an employer might ask for medical certification. Sometimes they do under the ADA. And it's really not clear at this point if employers are going to be entitled to medical certification. But if they are, under the ADA, their entitlement is very limited. They can't get an entire medical file for an employee. They can get only the medical information that's necessary to figuring out what they can do, what they can't do with their job. And so we do expect that that will be true with the PWFA as well. We expect that some employers are going to be using medical certification forms And they may be using a third-party administrator to handle all of this in the same way that they are under the ADA. If they do ask for a note from a healthcare provider, I would encourage you to use Work-Life Law's note writing tool on the Pregnant at Work website, and the link is in your handout materials as well. It's an absolutely fabulous tool that walks doctors and other healthcare professionals through just step by step in a very straightforward way, and make sure that the note that they write has all of the essential information, but doesn't have extraneous information. Next, please. If the employer rejects the employee's suggested accommodations, or just says, that's it, we can't make any accommodations at all, and as we know, the employee is not entitled to their preferred accommodation, but they can't be forced out on leave or forced to accept an accommodation if there hasn't been an interactive process. But if that is the situation, we suggest documenting it. And next slide, please. Okay, that is not the one that I thought that was going to come up, but in any event, that's fine. So let's say that the employer rejects all of the suggestions. One of the things that we suggest to people who call us on the hotline is that they look around and see what other employees are doing. And that way, if the employer is making the argument that a certain accommodation is not reasonable, if the employer is providing it to other employees, that undercuts that argument. And again, documenting is very important. If your client knows the name of the person and why the person got the accommodation, that's very helpful. And of course, the employer, if they're rejecting all of these requested accommodations, they need to come up with something else. They can't just say no, 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 no. In order to be in the interactive process, they have to come with some suggestions. And if you find that you're at an impasse, there we go, please feel free to give us a call on the hotline. We're happy to talk with you. We're happy to talk with your clients and strategize. And we will look at their rights under other laws as well as the PWFA. And to talk about those other laws, here's Jillian.
Thanks so much, Cynthia. So in our last few minutes here before we open it up to Q&A, I wanted to talk a bit about other statutes that are applicable potentially in this context. And the ones we're going to cover here are the Pregnancy Discrimination Act, or PDA, the Americans with Disabilities Act, or ADA, the Family and Medical Leave Act, FMLA, and also local laws that Liz alluded to in Philly and Pittsburgh, and then very briefly the Pump Act, which again, we're going to be having a separate training on, date TBD, but soon. Next slide, please. So most of you have probably heard of the PDA, and I definitely get the reaction when I tell people about the PWFA passing. I get the reaction, wait a minute, I thought the PDA already provided for this protection. I heard about Young versus UPS, a case that went to the Supreme Court involving a UPS driver who needed accommodation on the job. Doesn't the PDA provide this? And it does, but it also, because of its language, is somewhat limited and has some gaps, and the PWFA fills those gaps. But that doesn't mean that the PDA doesn't have immense continuing importance. The PDA is unusual among the federal anti-discrimination statutes because it actually has two provisions. Clause 1 clarifies that Title VII's ban on sex discrimination includes discrimination because of pregnancy, childbirth, and related medical conditions. That's sort of your what you might think of as sort of the plain vanilla kind of traditional discrimination. A pregnant worker is denied a promotion because of pregnancy. That is pregnancy discrimination, i.e. sex discrimination. And the PWFA does not affect Clause 1 at all. Clause 2 of the PDA requires employers to treat pregnant workers for all employment-related purposes the same as others similar in the ability or inability to work. So it was that clause under which accommodation claims were previously brought. PWFA largely displaces Clause 2 as the vehicle for bringing accommodation cases, but as our next slide will show, there is continuing vitality to Clause 2 for other kinds of cases. So next slide, please. So why would we still use the PDA? As I said, if there's some sort of discrimination based on pregnancy or a related medical condition, for instance, I think it's likely we'll be seeing claims relating to provision or seeking abortion care. That is probably not far off, given the recent developments. And so that is a kind of claim that would not be brought under the PWFA. It would be a PDA claim under Clause 1 of the PDA. Clause 2, would still be helpful if there's a dispute about whether your client's limitations were known to the employer. Remember that is an express provision of the PWFA. There's only an obligation to accommodate limitations that are known. And so if the employer says, wait a minute, I was not put on notice, your client could potentially look at the other procedures that under which the employer grants accommodations to other people. What are the procedures through which someone obtains accommodations, and does it require as overt a notification as PWFA does? Also, disparate impact Clause 2 claims are extremely valuable vehicles. For instance, we've done a fair bit of litigation in the area of attendance policies that we allege have a disparate impact on pregnant workers because they're overly punitive with respect to pregnancy in various respects. It also remains, Clause 2 remains applicable to all other claims that might arise with respect to other employment benefits but maybe disadvantage pregnancy while favoring other kinds of medical conditions. For instance, temporary disability policies that provide income replacement during a leave, or providing income replacement of any kind during a medical leave, but excluding pregnancy. That would be something that would be a Clause 2 PDA claim and not a PWFA claim. Next slide, please. The Americans with Disabilities Act. As you heard from Liz, there are myriad conditions that arise during pregnancy that may interfere with work and require some accommodation, but they don't rise to the level of being a disability within the definition of the ADA. Also, there are accommodations needed to avoid certain kinds of harm when someone has no complications, but they need to avoid certain toxins or other hazardous conditions. That's where the PWFA really comes in. Oh, could we go back? Sorry. So the pregnancy itself is not considered a disability, so PWFA helps with accommodation. But there are certain pregnancy conditions, and Liz alluded to some of them, like gestational diabetes or hypertension, that could trigger the ADA's protection. Additionally, there could be pre-existing conditions that qualify as disabilities that are exacerbated by pregnancy and require accommodation as well. So next slide, please.
I'm sorry, this is Kelly. I just need to launch the second CLE poll. It'll be up for 2 minutes, and Jillian, please feel free to continue. Thank you.
Great, thank you. So why would we still use the ADA if we have the fabulous new PWFA? to help us? Well, the ADA is very broad in its language. So it protects people who don't actually have a disabling condition, but are perceived as having one. Similarly, it protects people who may previously have had a disability, but no longer have it, but may face discrimination based on that past disability and stereotypes about future vigor or employability. Also, there is the ADA would cover harassment or other kinds of discrimination claims based on a disability, including a pregnancy-related disability. PWFA is not about harassment or other terms, conditions, or privileges of employment as Title VII terms them. The ADA also has among its provisions protection from adverse actions based on association with a person who has a pregnancy-related disability. So, for instance, someone who may not be pregnant themselves, but their partner is pregnant and experiencing disabling conditions. The ADA protects that individual. And some jurisdictions have especially generous interpretations of key provisions of the ADA, such as standalone violations for failing to engage in the interactive process, or a very narrow temporal window for the employer to grant the accommodation, or the requirement that the employer grant the accommodation within a very narrow period of time. We'll obviously be arguing for those kinds of protections to be imported into the precedent interpreting PWFA, but they're not explicit. And some jurisdictions, ADA case law could be very helpful for that reason when you're dealing with pregnancy-related disability. And finally, we've been talking a lot about talking to clients when they need the accommodation and how to set them up for getting the best accommodation. But sometimes you have a client who comes to you after they've been denied reasonable accommodation, and you learn that they never made the pregnancy known to the employer. They just made the disability known to the employer, but not the cause of it. And so the ADA would remain your vehicle there as well, potentially PDA as well. Because of you can't satisfy the known limitation requirement of the PWFA, but maybe under the ADA or PDA, you could have a cause of action. Next slide, please. So we're now up to the Family Medical Leave Act, which a lot of you may be familiar with, the FMLA. It is the one and only federal leave protection, job protected leave protection that we have here in this country, sadly. Provides up to 12 weeks of unpaid leave in any 12-month period. There are definitely barriers. You have to be eligible, which means that you have to have worked full-time for the employer for a full year. And then it's only applicable to employers of 75 workers or more. So it is, or excuse me, 50 workers or more. So it is definitely leaves a large swath of the population uncovered. But for those it does cover, it provides for time off for the worker's own serious medical condition, which includes pregnancy, and it doesn't have to be a complicated pregnancy. The need for prenatal visits or issues related to morning sickness is covered under the FMLA as a serious medical, within the serious medical condition of pregnancy. The serious medical condition of a spouse, child, or parent, birth or care of a newborn, and placement of a child through adoption or foster care. It may be taken intermittently, which is a real benefit, in increments of as small as an hour, such as for doctor's appointments. It also protects workers from the two prongs of protections are: it protects workers from interference with their FMLA rights, so interfering with their ability to take their leave, or somehow making it difficult or denying them FMLA leave. And then retaliation is taking adverse action for having exercised the right to take FMLA. Next slide, please. So why would we still use the FMLA now that we have the PWFA? because leave can be, as you've heard, one kind of accommodation that would be appropriate to seek under the PWFA. So why do you need FMLA leave if you've got that option? Well, it could be that there's leave related to your own pregnancy care that is, excuse me, self-care that is unrelated to pregnancy, forgive me, that may be necessary even during a pregnancy. A family member's serious medical condition needs attending to, and then the baby bonding, adoption, or foster care bonding. So those are all kinds of leave that PWFA would likely not cover, but remain important during the life of a pregnancy. Next slide, please. And I'm conscious of time, so we're in the final stretch here. Just very quickly wanted to note, as you've heard throughout the presentation, there are local and in some places state laws. There are 30 states now that have enacted various versions of the PWFA to fill the gaps that, as I mentioned, were in place in federal law prior to PWFA's enactment. So why would you use, if you're in Philadelphia or Pittsburgh, why would you rely on one of the local statutes in addition to or instead of PWFA? One thing is that PWFA, like Title VII and other other federal statutes, applies only to employers of 15 or more employees. Philly's law applies to employers of just 1 or more workers. Pittsburgh, employers of 5 or more. So that's a huge benefit because we tend to see that smaller employers are the least informed or may claim inability to accommodate because they have smaller workforces and claim that they can't accommodate. So that's very helpful. And then in certain substantive respects, the local statutes are broader or at least more explicit than PWFA. So they both expressly identify potential accommodations as suggestions to employers. I think that's something we'll be hoping that the EEOC includes in its regulations and that case law helps us start to identify, but to have it expressly laid out in the statute is a huge help. The Philadelphia ordinance also expressly covers reproductive health conditions and defines it in a very broad way. So includes abortion, infertility treatment, and contraception. Now, as Liz said, PDA case law, federal case law, does establish all of those kinds of care as pregnancy-related conditions, and we will be arguing as advocates that PWFA covers them. This is simply to say that in Philadelphia, it is actually expressed in the statute, and that is always a big help to have something spelled out. And last, Pittsburgh, and these are not the only, this is just an exemplar list. This is not the only, these are not the only ways in which the local statutes are helpful. These are just examples. The Pittsburgh ordinance expressly limits circumstances in which the employer can ask for medical certification. It's only when leave is sought as the accommodation and a few other circumstances. Again, that is TBD under the PWFA, the circumstances when medical certification may be sought by the employer. Having it explicit and limited in the local statute is also a huge advantage. There's more about both of these statutes in the handouts. This is just a quick overview, but there's lots more in the materials that you'll be getting after the presentation. Next slide. Oh, I'm sorry, there was one more, I apologize. So you heard about the PUMP Act, which relates to time and space for lactating workers. Why would you use the PUMP Act instead of PWFA? Because PWFA, again, requires accommodation of pregnancy and related medical conditions. And lactation is definitely a related medical condition. So if you can get accommodated under PWFA, why would you use PUMP? Well, a couple different reasons. It again applies to employers of all sizes as opposed to the 15 or more covered by PWFA. It doesn't have an undue hardship defense available to the largest employers, whereas PWFA does allow employers to claim undue hardship. It specifically mandates how long the accommodation will last, up to 1 year, which PWFA does not. That's something that the regs and subsequent case law will be defining, just how long is a reasonable time for a pregnancy-related accommodation. It specifically mandates where and when pumping may occur. PWFA does not have that kind of specificity. And then it also has certain additional remedies, not just through the private right of action that it now includes and that PWFA includes, but also liquidated damages, for instance, which refers to back pay being doubled. And there's some resources there, and they're also listed in the written materials. It's enforced by, PUMP isn't going to be enforced by DOL, not the EEOC. Next slide, please. Okay, that's our contact information. Please keep it and use it. And I'm sorry we went a little bit over with the presentation, but now would love to open it up to questions in the chat.
There are some questions in the chat, and if you guys are okay with it, people can also just unmute themselves and ask their questions or give their comments, if that's okay too.
Absolutely.
Let's see, it's going to take me just a second to catch up here in the chat. The PWFA does not apply to independent contractors, correct?
But Liz makes an excellent point that employers have every vested interest in creating that definition for themselves of what the worker's status is, and there are well settled parameters in case law about what defines an employee versus a non-employee. So don't let the employer be the last word on that.
Excellent point. Other questions? Wow, we must have been really, really comprehensive.
It's funny, in all the trainings I do, the sessions I think there'll be a ton of questions, there's not, and the ones where I think there'll be no questions, there's a ton of them. So last chance, anyone, if you want to unmute yourself or type in the chat box.
I just want to reiterate that the Center for Work-Life Law has our free legal helpline for workers. Please send folks with questions related to work, actually, or school, and pregnancy and parenting, caregiving to us if it's not within your capacity to assist them. And as these calls come in, please reach out to Jillian at the ACLU or Cynthia or me at Work-Life Law. And we are eager to assist. And as I think Cynthia or Jillian said earlier, it helps us because then we can learn more about what's happening across the country.
Okay, well, if
Can I ask, you said that you do have a legal network that you refer the cases back out to once you get folks contacting you through your helpline. I'm just curious, is that mostly, some of us here I think are from legal services providers and others might be from slightly different kind of public interest firms. So I'm just wondering if it's NELA type plaintiffs employment lawyers that are in your network, or is it also groups like Women's Law Project, et cetera?
It's both. So we have lawyers in every state now, sometimes several in every state, and we send cases to them. What we do is, we vet the cases through our hotline, make sure that there's a good set of facts there so that we're not wasting anybody's time. And then we make the connection between the lawyer and the hotline caller, and then we stay involved. So if there are questions that the hotline caller has, they can always, just run it past us, get another opinion. but also we help the lawyer. So we've got a sample forms and briefs bank that we can share with people. We have a database of cases from all across the country, so we can provide case law to the lawyers. We talk strategy with them. We help them plan discovery. We often will look at draft complaints, draft motions. So we do a lot to stay involved, try to make it easier on the lawyer, try to make sure that there's a good outcome on the other end. And we invite people to join. It's an invitation only process, but I imagine everyone on this call has the type of experience that we are looking for. So that is just a formality. There's an application we ask people to fill out so that we have the appropriate information when we're trying to match callers and lawyers. But just send me an email, cynthia.calvert@worklifelaw.org. My contact information is in the handouts, also in the PowerPoint, and I'm happy to give you more information and send you an application. We'd love to have people join.
Yeah, well, we do employment law at our legal services program, and we do tend to focus on the cases where we can get someone keep working or maintain their job rather than the litigation end. So that's where we find like we can refer out the litigation potentially to the private bar, but there's a lot to be done there, for folks to just maintain and preserve that job. So I appreciate all you've put together, especially the brainstorming portion of it. I think that's going to be super useful.
Wonderful.
Yeah, that was a real, we've been trying to get this law passed for a decade, and that was really an important lobbying point, was to say this is a law that it's unquestionable that there will be litigation in some circumstances, but clarifying employers' obligations and the interactive process being written into the statute, that it's meant to avoid litigation. It's meant to nip these issues in the bud. And we made the point, and we actually had the Chamber of Commerce on the weighing in support of the statute, which is not usual for us. But they've been complying with or supposedly complying with the ADA for over 30 years, and this is the same kind of structure. And so that's how we tried to explain it. This is not rocket science. This is not radical. They've been doing it for countless other people over the years. We only have a couple minutes left, but there's an excellent question that was put in the chat asking about whether there's a time limit after childbirth when PWFA accommodations or accommodations pursuant to PWFA might be available. The short answer is that there is not a specific time limit. I myself have successful represented a client who was a police officer and developed after childbirth, developed carpal tunnel, which is very common. Joints loosen and ligaments get stretchy, and she had extreme pain and could not hold her weapon because of her carpal tunnel. And so she was relieved from the obligation of having to take her recertification training that she was going to have to take after taking maternity leave. Postpartum depression obviously is a very real concern. So I'll let Cynthia and Liz weigh in here, but I think the key here is to be involving the health provider who is able to make the link, saying that whatever the condition that's occurring right now is a related medical condition to pregnancy. And of course, lactation occurs in the postpartum period as well, but I was thinking about non-lactation physical issues. So no magic number, and that's actually something when we are giving comments on the regulations that we're going to be very strong about, is that the one individual may need different accommodations throughout different periods of pregnancy, even within the pregnancy, first trimester versus third trimester, and then returning to work may implicate certain needs for accommodation as well. So no magic number.
That's been our experience as well. And I know that we are out of time. So Jillian, any parting words or? Just say thank you to everyone for joining us, and please get in touch if you have questions.
Absolutely. Would love this to be the beginning of the conversation, not the end. Thank you all so very much for your time, and we look forward to working with you.
On behalf of Plan and the network, thank you, Jillian, Cynthia, and Liz, so much for joining us today and giving us all this helpful information. We really appreciate it. Have a great rest of the day, everyone.